Welcome to the Catholic Employment Relations Podcast, CER Matters. Subscribe for the latest information on current employment law topics.
Welcome to CER Matters, your employment law podcast, where we discuss current and topical issues that affect your workplace. Today, I'm joined by Grant Connolly and Martin Dunn, CER employment specialists and lawyers.
Hi Sheila, thanks for having me as part of our first podcast.
Hi Sheila.
Let's jump straight in. Today, we're talking about the Secure Jobs Better Pay Amendment to the Fair Work Act, which was passed late last year. When are those changes going to be effective?
Several of those changes are already in effect. They came into force the day after the bill received royal assent. That was on the 6th of December last year. Many of the other changes will come into force at various points throughout 2023, with most of those commencing from the 7th of June.
So in our first few podcasts, we're going to focus on those provisions that are already in force. Let's start with the abolition of the Australian Building and Construction Commission and the Registered Organisations Commission.
Thanks Sheila. The Australian Building and Construction Commission, or ABCC, exercised regulatory responsibilities dealing with workplace relations and matters in the building and construction industry. These responsibilities included investigating and taking action for breaches of legislation. From 6 February 2023, the ABCC has been abolished, and its responsibilities and all existing court proceedings, which were commenced by this body, have been transferred to the Fair Work Ombudsman. The Registered Organisations Commission, or ROC, exercise responsibilities as an independent regulator of registered organisations, which include employer associations and unions. The ROC will be abolished and its functions and staff transferred to the Fair Work Commission by no later than 6 June 2023.
So Martin, can you tell us why were these bodies abolished?
The reason given for these changes is that the functions exercised by both the ABCC and the ROC could be adequately performed by the Fair Work Ombudsman and the Fair Work Commission, and therefore they were no longer required. Time will tell.
Okay.
Thanks for that. I think our listeners will feel a bit more informed about the changes in relation to the abolition of the ABCC and the ROC. So I was wondering if we could maybe take a look at some of the steps that they need to take in relation to staff confidentiality and secrecy surrounding staff remuneration.
Sure, this is a measure that the government introduced to address the gender wage gap. The provisions give a workplace right to employees to disclose their remuneration to other employees, and that includes anything that determines their remuneration outcomes, such as bonus arrangements. Employees also have a workplace right to ask other employees about their remuneration. Of course, employees have no obligation to share this information with other employees, but they now have the right to disclose it if they wish to do so.
Okay, I know a lot of employers have employment contracts in place with clauses that state that their salary is confidential and must not be shared with others in the workplace. What happens to those clauses?
If that contract of employment was made or varied after 7 December 2022 and has a clause in it which restricts an employee's right in relation to pay secrecy, that clause will have no effect. There are also civil penalties that will apply from June this year that can be imposed upon an employer. If an employer enters into a written agreement with an employee, not just an employment contract, and that agreement contains a term which is inconsistent with an employee's right in relation to pay secrecy, it will amount to a contravention, and the employer may be subject to civil penalties.
Okay, so can either of you recommend what employers can do to avoid contravening the Act or retaining terms and agreement which won't have any effect?
I'm happy to take that one. I would recommend that employers review your employment contract templates, review your policies and your procedures, and remove any clauses in there which would be inconsistent with those new pay secrecy provisions. Additionally, if you need to make a variation to an existing employment contract, so that is a contract of employment already in place for an employee, review that contract and make sure that it does not contain a pay secrecy clause, and if it does, have it removed. Lastly, I would ensure that people leaders in your organisation are aware of these new pay secrecy provisions so that they don't do anything or say anything which would offend an employee's workplace right to ask or disclose their remuneration to another employee.
Excellent. So if our listeners are in any doubt, they can contact our office and we can clarify the correct rates to make sure that they're compliant. So if we can now move on to the topic of prohibition of advertisements, the contravening pay rates, if you can clarify and explain that change a little bit more for our listeners.
This is a new provision that prohibits employers from advertising or causing to be advertised employment at a rate of pay that will contravene the Fair Work Act or a Fair Work instrument. So that includes advertising pay rates which are below what is provided for under the relevant modern award or enterprise agreement, and that applies to any jobs that are advertised from the 7th of January 2023. An employer may be liable for civil penalties for any contraventions of that provision. For example, if an employer posts an advertisement on their careers website for a job at a lower rate of pay than the relevant classification in an enterprise agreement that applies to that work, that would amount to a breach, unless that employer has what the legislation calls a reasonable excuse.
So you mentioned reasonable excuse, so what would constitute a reasonable excuse?
Well, that term isn't defined in the Act. However, the defence of reasonable excuse will depend on the circumstances of the individual case. It would include an excuse which would be accepted by a reasonable person to justify the non-compliance. An example of that would be that the employer had relied on advice from a relevant professional about compliant pay rates, and that advice turned out to be incorrect.
Okay. So let's discuss when our members are ready or need to initiate bargaining. How does that work, and how do the changes affect enterprise bargaining?
So the amendments around initiating bargaining make it easier for unions to commence bargaining for a single enterprise agreement. Prior to the amendment, bargaining usually commenced when the employer initiated it or when the employer agreed to bargain. Since the amendment came into force, unions can initiate bargaining simply by writing to the employer. And that applies in situations where the existing agreement has passed its nominal expiry date and it's passed it within the past 5 years, and the proposed agreement has a substantially similar scope to the existing agreement, and where a single interest in employer authorisation did not cease to be in operation when the existing agreement was made. And that's a significant change from the previous laws, where a majority support determination or a scope order was required to force an employer to commence bargaining. That means that in those circumstances, unions are no longer required to demonstrate that a majority of employees want to bargain. When a union makes this request in writing, it means that the employer is obligated to commence bargaining, and it also triggers those good faith bargaining obligations under the Act.
Okay, so what about other types of agreements, those that aren't single enterprise agreements? Are they excluded from this change?
This method for initiating bargaining does not apply to proposed Greenfield's agreements, a multi-enterprise agreement, that is a cooperative workplaces agreement, a supported bargaining stream, or the single interest bargaining stream.
Okay, so there's been some changes to the requirements relating to terminating enterprise agreements. Can you tell us a bit about that?
Sure. it's now much more difficult for employers to unilaterally terminate an enterprise agreement. Prior to the amendment, all the employer needed to do was satisfy the Commission that termination was not contrary to the public interest. The Commission would take into account the views of the employees and the unions, and they would consider the likely effect that terminating the agreement would have on them. Now, where an agreement has passed its nominal expiry date and an employer applies to terminate it, the Commission must be satisfied that termination is appropriate in the circumstances, and that either the continued operation of the agreement would be unfair to the employees covered, or that the agreement does not cover any employees and isn't likely to in the future, or that all three of these following criteria are satisfied. A, that the agreement would pose a significant threat to the business's viability, and that the potential for the termination of employees would be reduced, and that the employee has given a guarantee of termination entitlements.
Okay, so those are the limited circumstances in which an agreement can be unilaterally terminated. Does the amendment specify the factors that the FWC needs to take into account?
Yes, the amendment states that the Commission must have regard to certain factors, including whether the application for termination was made at or after the notification time, and whether bargaining is already occurring, and whether the termination of the agreement would adversely affect the employee's bargaining position. The intention there is to prevent an agreement from being terminated as a bargaining tactic. The result is that an employer now has less leverage in dealing with agreements with unsustainable conditions. It's also important to note that the Act provides for an alternative method of terminating an agreement which is not affected by the amendment, and that's where a vote is held and the termination has been agreed to by a majority of the employees covered by it.
Okay, so despite everyone's best efforts, sometimes errors occur in these enterprise agreements. So maybe we can discuss how we deal with errors in enterprise agreements. The amendment gives additional powers to the Fair Work Commission to correct errors. What are those new powers?
The Commission now has power to vary an agreement to correct or amend obvious errors, defects or irregularities. In addition, it can validate a decision to approve an enterprise agreement or variation where the incorrect version of the document was inadvertently submitted to the Commission. Also, the Commission can retroactively apply the approval to the enterprise agreement that was made instead of the incorrect version that was lodged.
So, can you tell me, why was the Commission given these new powers?
This change was made to reduce the time, expense and complexity involved with rectifying errors in enterprise agreements that have already been approved. So this is a welcome change for employers and employees, because making errors in drafting agreements is very common for a whole range of reasons. You've got typographical errors, too many people changing the same document, communication breakdown, copy and paste mistakes, errors in Excel formulas, the list goes on. Those mistakes aren't always picked up before the agreement is lodged and can cause further errors being made in the way that those agreements are then applied. So those situations can lead to unintended outcomes, they can lead to disputes in the Commission, and it can affect an employer's credibility with its employees. So the Commission has had the power previously to correct an obvious error in its decisions under Section 602, but it hasn't previously had the power to correct an enterprise agreement. Now it has that power.
Sounds like a very positive move. So maybe we could turn to another one of the provisions, that is the sunsetting of so-called zombie agreements. What are zombie agreements?
So they are very old industrial instruments that were made before the Fair Work Act or during that bridging period in 2009 when we were transitioning between work choices to the Fair Work Act.
So Grant, would it be safe to say that there are very few employers who still have a zombie agreement?
That's right. This has no relevance to most employers, only those few who are still applying those very old instruments.
And if an employer has a zombie agreement, what will happen to it under these amendments?
They will automatically terminate after the sunset period, which will expire on 7 December this year. Unless extended or replaced by another enterprise agreement before the 7th of December, a zombie agreement will cease to cover or apply to employees, and relevant modern awards may apply from that time.
So Martin, for our listeners, is there anything that an employer operating under a zombie agreement should do right now?
Well, by the 6th of June, employers who have a zombie agreement are required to notify affected employees of that agreement that will expire by the 7th of December. These employers should seek advice as soon as possible concerning the steps that they need to take now to ensure a smooth transition from their zombie agreement.
Okay, fantastic. I think we'll wrap it up there. We look forward to our next episode. Thank you very much, Martin and Grant, for your time and for sharing your experience.
Thank you, Sheila.
Thank you.
Thank you, Sheila.